Vehicle Licensing Authority. The petitioner had appealed against the said judgment of the High Court, presided over by Justice Ackaah-Boafo, to the Court of Appeal. And the Court of Appeal, in suit number H1/10/2023, dated 22nd June 2023, delivered judgment on the issues, having considered the totality of the evidence and the judgment. The appointment committee cannot therefore be constituted into the Supreme Court and Judicial Council to review the judgment of the Court of Appeal and take disciplinary action respectively. We are of the view that all issues raised in the petition has been appropriately dealt with by the court. Honourable members, the petitioner furnished the committee through the clerk additional documents. The committee duly considered the additional document and realized that it was a petition by the same petitioner alleging corruption against one Charles Aidan, Deputy Director of Finance of the Judicial Service, addressed to the Chief Justice on 26 April 2021. The Chief Justice investigated the matter and found no wrongdoing against Charles Aidan, the Deputy Director of Finance, and accordingly communicated his findings to the petitioner therein, who is also the petitioner herein. The additional documents have no nexus to the petition he wrote to the appointment committee and have nothing to do with the nominee before us. We therefore see no reason why a petition and finding involving Charles Aidan, the Deputy Director of Finance, could be admitted and used as evidence against the nominee, His Lordship Justice Tawiah Ackaah-Boafo, since the documents have nothing to do with him. Honourable members, Article 1273 of the 1992 Constitution of the Republic of Ghana says that a justice of the Superior Court or any other person exercising judicial power shall not be liable to any action or suit for any act or omission by him in the exercise of the judicial power. The complaint against the nominee is about the exercise of judicial power in conducting the matter leading to the judgment under reference. The committee this morning ruled that the petition is frivolous, vexatious, worthless, unmeritorious, and it is baseless in law and the facts, a complete abuse of the process. During the committee's meeting, our attention was drawn to publication by some media houses yesterday. Before the committee's meeting today, allegation that Parliament had thrown out the petition against Supreme Court Justice nominee, Justice Kweku Tawiah Ackaah-Boafo, and that he was scheduled to be vetted today. We shall appropriately consider the conduct of the media houses if the need be. We are therefore proceeding to vet the nominee under reference. Thank you for your rapt attention. Honourable members, we shall appropriately consider the conduct of the media house if the need be, and we are therefore proceeding to do the vetting. I will then give the floor to the minority leader if he has a brief remark on the issue at stake.
Chairman, thank you for the opportunity. Chairman, I am in agreement with the views you've expressed for and on behalf of this committee. Indeed, as a country, we need to veer off from trivialities and situations where we subject people's reputation to undue public ridicule. I am happy that this committee has boldly stood up for democracy, rule of law, and in helping deal with matters as frivolous as what came before us. Unfortunately, if you look at the ongoing trial of the Chief Justice of the Republic, we have one Daniel Ofori who refers to a judgment which the Chief Justice was involved as a basis for attacking the woman and calling for her removal. If you also read Yakubu Akogo Ayamga, similar frivolous allegations are made that the Chief Justice made certain pronouncement against him in open court. Unfortunately, these two scenarios have been deemed to constitute a prima facie case amounting to misconduct, justifying inquiry into the conduct of a Chief Justice. And the Chief Justice of the Republic is on suspension as a result of this. I am happy that as a committee, we stood firm to the test and we have risen above pettiness and trivialities. Chairman, my second comment has to do with feedback from certain quarters regarding the minorities' stance on some of the issues that have come up as part of this vetting. I would want to pray the public to appreciate where we're coming from. We are not here to get personal. We are here to deal with the law and issues of public policy, good governance. So for those who are saying that, oh, you guys are lawyers, why are you subjecting nominees to all these hard questions when you appear before them? They are also likely to do that to you. Well, my answer to them as a person, I speak for myself. If Mr. Speaker grants me that exemption to practice, I will do as I've always done. If a judge believes that he should rule against me because I did my work, so be it. I've never been afraid to practice at the Supreme Court. When I was in opposition, 2013 to 2016, I was a regular visitor in that court. And I was never deterred by any action or any ruling against me. I will do my job, and I will do so out of great deference, out of great respect. And I'm not here to attack anybody's person. So I want those who are being impatient and intolerant to please understand the space I am in. That is the work of the minority. Our job is to enrich democracy, and that's exactly what we are doing. Don't get irritated. Please bear with us. Thank you very much.
Honorable members, before proceeding to administer the oath, let me place on record that the issues raised by the minority leader regarding the petition against the Chief Justice are before another body and will be dealt with in accordance with law. There was also no evidence or issue of a judge dealing with the minority leader in any manner whatsoever We are dealing with issues of facts and applying the law to the facts. So I plead with the minority leader not to preempt anything. I will therefore go ahead and call on the clerk of the committee to administer the oath.
I do hereby administer the oath.
I, Kweku Tawiah Ackaah-Boafo,
Do in the name of the Almighty God swear
do in the name of the Almighty God swear
that the evidence I shall give before this committee
that the evidence I shall give before this committee
touching the matter in issue
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you.
Honorable members, may I proceed by asking the nominee to give us a brief background.
Thank you very much. Good morning, Chair. Good morning, members of the committee. I'm Kweku Tawiah Ackaah-Boafo. My mother, the late Agnes Quayson, is from Wassa East, Mamponso, raised in Aboso, settled at Insusaiden in the Western region. My father, Nicholas Eduaka, is from Western North. I'm a Fie and Akekrum. So from the records, I think I'm the first nominee to come from the Western North. And for the Western region, I'm actually the third nominee from the Western region. I had my secondary education. I started from St. Augustine Secondary School at Bogoso in the Western region. I left there after 2.5 years, came to Winneba Secondary School, Winnisekwe. I had my O-levels. I had my A-levels at Secondary College. From there, I did my national service at Aboso in the Western region. Came to University of Ghana, Legon. I was a resident of the Commonwealth Hall. I went through with an LLB degree. From there, I went to Ghana School of Law. I was called to the bar in 1996. I did a brief practice. I did my pupillage at Bosonchi Salmon Associates in Takoradi. From there, I joined my brother, Ben Akar-Jesse, to start Kendrick's law firm. In 1999, I left Ghana. I went to Eric Castrine Institute for Human Rights and Public Administration, University of Helsinki. I had my LLM there. I was then enrolled in a licentiate program, which was towards a PhD, but I didn't complete it. So I migrated to Canada, where I enrolled at the University of Ottawa Law School for my pupillage. I was called for my post-Canadian bar. I was called to the Canadian bar as a barrister and solicitor and notary. And I practiced law in Toronto, Canada as a criminal defense counsel. I also appeared before many of the other courts, the federal court, the superior court, did many work there. In 2015, I was appointed as a justice of the High Court, 1st April. I spent 7.5 years at the High Court. In December 2022, I was elevated to the Court of Appeal, where I have continued to work till now. I am married to the beautiful lady behind me, Joycelyn Kweku Ackaah-Boafo. We are blessed with 2 children, Nick and Maud. I'm a born-again Christian, a member of the Full Gospel Church, and grace has found me. I call myself a PGG. I'm a product of God's grace. So I am here today to be vetted for the Apex Court of Ireland. Thank you very much.
Thank you, nominee. Honourable members, we then proceed to take questions. I will start with the subject matter committee members, and I'll call on Honorable Bitsidi to start.
Thank you very much, Honorable Chairman. Congratulations, my Lord, I have a few questions for you. The first is, my Lord, are there enough lawyers in Ghana? And if your answer is no, what do you think can be done to increase the number of lawyers in the country? Thank you.
Thank you very much, Mr. Chair. Well, at the last count, the information I got, because I teach at the law school, is that between 1877 and 1963, there were 570 lawyers in Ghana. And I mentioned 1877 because of the Judicial Act. But from 1962 till now, as of May 2015, at the last call, I think the lawyers from 62 to May 2025 is about 10,400 and something. So in effect, many lawyers or lawyers in Ghana in total would be about 11,000 something. From the Ghana Bar Association portal, as I asked around, you see practicing lawyers will be about 8,000. To that extent, there are not enough lawyers in Ghana, because if you look at our population, then you have about 2,000 people to a lawyer. If I compare it to Ontario, in 2020, the Ontario population is 14-point-something million with over 56,000 lawyers, which will be about 1 to about 7,700. So to that extent, no, there are not many lawyers in Ghana. So I think that something ought to be done. What should be done is something for discussion. And you asked me what should be done. I mean, at this stage, we know that it's the Ghana School of Law that train lawyers. There has been conversation that the institutions that train the LLBs should be allowed to do the professional. I will hasten to add that we need to be very careful how we do that. Because if many of the LLB schools producing candidates, the question to be asked is, do they have the requisite material and the qualified lecturers to teach there? Because let me say this. If you produce, let's say, 100 graduates, and they write the entrance exam as it exists now, and you don't have more than 10 people passing, then I think there's something wrong. So yes, we should enlarge it, but we should be very careful, because after LLB, somebody must do pupillage. Do we have qualified chambers to train the lawyers who will qualify? If we have over 8,000 lawyers and there are only about 1,200 registered chambers, there will be a problem. But yes, there's a need to enlarge the number, but it's a conversation that should be had deeply and without any emotions. Thank you.
My Lord, we know your background. As a lecturer, you can be lecturing for the whole day, but we don't intend keeping you for the whole day. So I humbly plead that we observe the brevity principle and short answers will be given to questions.
Thank you, Mr. Chair. Very well noted.
Yes. Any further question?
Thank you, Mr. Chair. I have no follow-up question, but I have a second question for my Lord. My Lord, there is a troubling trend of people using social media to abuse or defame other people. Some hold the view that suing them and awarding damages against them amounts to curtailing freedom of expression. Do you agree with this position, my Lord?
Thank you, Mr. Chair. Mr. Chair, the Venerable Justice, a well-known justice known to everybody who has studied the law, the name just escaped me, from Britain, and I'm sure by saying Venerable, all of us remember him. In the case of British Steel Corporation versus Granada, said, Lord Denning said, freedom, if you want to deserve freedom, the press deserving freedom, they must work for it, because free speech is not taken. In Pakenham and North Carolina, Justice Scalia said, acting on social media, it is like the old style writing in newspapers. Therefore, there must be some guidelines there. So if you go on social media and you use that to abuse somebody, and the person thinks that he's defamed, I think that going to the court will not be gagging anybody. There must be responsibility. People must be responsible on social media. Thank you.
Any further question?
Yes, Mr. Chairman. No follow-up question, but I have a third question. My Lord, my final question to you is that some people argue that the practice of impaneling judges by the Chief Justice allows the Chief Justice to favor certain judges for particular cases. I'm talking about in the Supreme Court. Do you think something should be done about this particular situation? Thank you.
Thank you, Mr. Chair. I think the Chief Justice and paneling judges is an administrative work. But the question you pose also gives me the impression that there's that perception that a Chief Justice can use that negatively or select something. My view is that we should have a statutory legislation about electronic impaneling. Even at the Supreme Court, there should be panel heads with the Chief Justice as one of them. Because my understanding is that at the appellate court, there are senior judges, middle senior judges, and junior judges. So that if you have panels of, let's say, 4 at the Supreme Court, with the most seniors as the heads, and cases are assigned electronically, and it goes to panel 1, which is headed by Judge A, then it cannot be changed. It will help to take away the perception of abuse of a Chief Justice using paneling to do favoritism. That will be my answer. Thank you.
Any follow-up?
Mr. Chairman, there will be no follow-up. My Lord, congratulations, and I wish you well. That will be all for now.
I'll proceed to give the floor to Yaobuama Jr.
Thank you very much, Mr. Chairman. Congratulations, my Lord, for the elevation. My Lord, I believe that when the bench is filled with incompetent judges, they will deliver low-cost decisions at the expense of the citizenry that we represent. In your view, how do we monitor and eliminate incompetent judges who see the bench as a benign retirement from the rigorous private practices that we have?
Well, thank you, Mr. Chair. Incompetent judges, I think that to be elevated to any of the benches, individuals go through processes. So once they are appointed, they are presumed to be competent. Now, the judiciary certainly has an assessment section that they assess judgment. I work at the JTI. There are times that a judge may err, that a reference may be made for judges to be retrained at the JTI. And I think that is one means of assessing whether or not people's knowledge in a particular area is not good. But we know the rules for appointment. Once the person is qualified and it's a lawyer and it's appointed, there's a presumption of competence. And so it is just an issue of building capacity. Thank you very much.
Follow-up, Chair. The conversation for the Ghanaian people is justice delivery. That seems to accord to the benefit of the people we represent. And so it is not just only a matter of the appointing process, but a form of assessment that assures us that judges, whether in their promotional, whatever, is based on competence. So from the Supreme Court that you are going to, what are some of the recommendations in terms of monitoring to establish that competency outweighs any other consideration for appointment?
I honestly believe in an independent judicial commission for elevations and appointments. And that commission, if it's put in place statutorily, would then consider some disappointment. They will assess your work, they assess what you've done, what you are able to do, and that will become the basis. And by the way, in other jurisdictions, you can't even be a judge without voluntary work that you have done for the community to see that you've served them prior and you can serve them on the bench. So I think that that's one way of assessing competence. Thank you.
Honourable members, as we want the nominee to be brief, we should also be brief in setting the foundation for the question. I'll give the floor to Ackaah-Boafo.
Congratulations, my lord.
Chairman, with respect, not to chip away your powers, but I plead with you to allow things to flow.
My lord, you stated that the population of Ontario is 14 million and they have 57,000 lawyers. 56,000 lawyers. The size of the Ontario economy is $887 billion. The size of the Ghanaian economy is $8.83 billion. $82 billion. Don't you think that the demand for lawyers in Ontario is driven by the size of their economy as opposed to the population of Ontario?
Thank you, Mr. Chair. I think that is part of the analysis, but the Ghanaian economy also call for judges in this nation. Let's be honest. Western North, I'm not sure they have more than 5 lawyers there. And it's a regional capital now. You have lawyers work there. So I think that there's a need for that increase in our space as well, because businesses, district assemblies, and private individuals certainly require the services of lawyers. Thank you.
I'm going to ask a follow-up. My lord, in the 80s, one of the busiest places for legal practice was Western Region, particularly Takoradi and Kumasi, because the economies of these places were booming. And so legend has it that some of the best lawyers, in fact, judges of this country, practiced either in Kumasi or Takoradi. And at the time, their population was very small. And so, by way of follow-up, don't you think that the emphasis really and truly is more on economy than the size of the population?
Your contention is right, but you also recognize that for some time now, Ghanaians have become aware of their rights. I mean, look at growing up, there were only few high courts. They were only based at the regional capitals. Now high courts are district capitals and other places. If the courts are there, people understanding their rights will go there. And sitting as a judge, knowing that somebody self-representing is one of the challenges any judge will face. So I think the economy is a consideration, but the population as well, knowing that they have somebody who can advocate for them is also very important. Thank you.
Well, Honorable Imie, you have the floor.
Thank you, Mr. Chairman. Congratulations, my lord, and welcome to the committee. My lord, we'll start with judicial integrity. You would agree with me that judicial integrity is very important to sustain the confidence of the public in the judiciary. Can you tell this panel, how have you, as a judge since, I think, 2015, when you were appointed to the bench, maintained your integrity? Thank you.
Thank you, Mr. Chair. I think the judiciary, I will call it the arbiter of the nation. And therefore, the presumption is that when people have been entrusted with power to administer justice, they ought to be ethical. Judges have code of ethics, and that is what is supposed to guide us. How have I done mine? I think that I find this as a fulfilling opportunity to serve this nation. And to serve the nation means that I must strive to be unashamedly ethical. And being ethical means that you guard your integrity in doing your work. Thank you very much.
Now, as a justice of the Court of Appeal, if you should discover misconduct from a fellow judge, how would you approach that?
Well, if it is a misconduct that calls for a report, certainly I think that even as lawyers have obligation to report their colleagues who are caught in misconduct to the General Legal Counsel. As to whether or not they will do it is another matter. Because anytime I pose this in classroom, the student go, no. So, but if I see a judge in a situation like that, which calls for a complaint, I think I will speak to a senior judge about it. And if it is something that can be resolved without making official complaint, that will be done. If it ought to be officially complained, I will do that. Thank you.
My Lord, in your view, we're going to a different area, AI. In your view, as a justice of the Court of Appeal, do you think the judiciary is prepared or poised to use artificial intelligence as evidence in the determination of cases, considering the fact that these days it's so easy to generate anything?
I will highly recommend the judiciary to be AI literate. The judiciary of Ghana must endeavor to make the judiciary AI literate, because that is the new trend. However, we need to be very careful engaging this, because if we are all literate and as to how it operates, then we are in the front end, and then we'll be able to know the dangers associated with it. Many countries like Canada and UK have guidelines for judges. And so, whilst I recommend that AI literacy should be embraced by the judiciary, then we'll be required to have guidelines to guide judges, so that when lawyers have filed processes with hallucinations, we'll be able to know it and address it. Thank you.
Now, my final question. I believe you are familiar with this statement. It's been in the media for quite some time now. The packing of the Supreme Court by the president of the day, unquote. Do you think that President Mahama is packing the Supreme Court to secure political advantage, or you think that you are being sent to the Supreme Court to deliver justice according to law?
My answer will be the latter part of your question. But on the issue of capping, I will respectfully ask this committee and this House to, before you talk about numbers, look at the jurisdiction of the courts. Because the court has over 8 jurisdictions. The last time I checked, with respect, Ghana may be the only country with a Supreme Court which sits every week. In Canada, Supreme Court sits in sessions, winter, spring, and autumn. So they sit, and they don't deliver more than 65, they deliver between 65 and 80 cases a year. They receive over 500 cases. They do filtering. And at the end of the day, they may accept about 120, and they will do about 65. So before we talk about numbers, let's look at the jurisdiction. And with that, let's try and give some of this jurisdiction to the Court of Appeal to deal with it. And then we can talk about numbers in regards to the Supreme Court. Thank you.
I'm very grateful. Mr. Chairman, I'm grateful. Just that from his CV, it's not a question. From his CV, when you look at hobbies, I see he's indicated that he enjoys singing. We were in the same hall, Commonwealth Hall, and I never saw him in the choir.
So everybody that believes in singing must be a member of the choir. Honorable Tampuli, you have the floor.
Thank you, Mr. Chairman. My Lord, you are welcome and congratulations. See that you are a V-mate. I would have asked you to hold something, but it's all right. We'll do it another day. My Lord, I'm taking a cue from the question that was asked of you about empaneling by the Honorable Bidzidin. Now, there are a long line of cases which deals with especially the rule that a person shall not be a judge in his own courts. And from the cases of Attorney General versus Salah, Kwashi Aidan versus Akufo-Addo, Bosin and Apalu, and so on and so forth, all the way to the recent cases. You see that the issue GBA versus Archer and so on and so forth, and Aban. Now, those cases have arisen because the Chief Justice, maybe his powers or decisions are being contested, and he is supposed to be the person empaneling the courts. Now, your proposal that we should digitalize the platform is a very, very innovative one. Where do you think the Chief Justice would be in such matters like this? My Lord, the Chief Justice, the acting Chief Justice is sitting right behind you. I'm not too sure if you are depriving him of something by digitalizing the empaneling platform.
Thank you, Mr. Chair. As I indicated, it's an administrative function of the Chief Justice. But we also live in a society where perception counts, because anybody, even lawyers, will ask that why is he the person at the end of it and is the one appointing judges? So that is why I think of such a proposal. The CJ, him or herself, will be maybe a panel head. But in a situation like that, his or her panel cannot hear the matter, and the matter could be assigned to the other panels which are established. So I think it's something that we ought to look at, because if people perceive that using your powers to administrative empanel leads to a favoritism, sometimes sidelining some judges who ought to sit and are not sitting, and others are being overburdened, I see this as one way of solving that problem. Thank you.
Thank you, Mr. Chair. Mr. Chair, I have a quick follow-up. So under what circumstances would you recommend that the Supreme Court, for instance, departs from its earlier rulings in respect of that subject matter, that if a statute says that the person should sit, the person should sit, the doctrine of necessity and all of that? Is there any other circumstances that you see that the Supreme Court can depart from that? Thank you.
Sorry, is this in line with empaneling? Yes.
That is so.
I think that we live in a society now where many of my colleagues are doing further education. People have specialized knowledge. I have on my own sponsored myself to World Intellectual Property programs yearly, and insolvency programs. So if you have a judge who has a particular expertise in an area, and there's a subject matter that judge's expertise will help, that will be one of the exceptions, because then we'll help develop our jurisprudence. Thank you.
Mr. Chairman, I thank you. Congratulations. V-mate. Sharp.
After sharp, what is it that you cannot add? Honorable Omar, you have the floor.
Thank you, Chairman. My Lord, congratulations. My question is in reference to the constitutional review. At least we've had the Constitution since 1992. If you were to submit a question or a suggestion, what will you do? What will be the suggestion to the Constitutional Review Board?
Thank you, Chair. I think The first thing I seem to have mentioned it when I was asked the question. I will seriously recommend that we should have an independent judicial commission for purposes of appointment. And as it exists in Kenya and other places, so that people who are qualified, be they sitting judges or those in private practice, can apply. They assess your work. Once they filter it through and they think that you are qualified, it then goes to government, which will not have any control over the candidates presented. So that would be one thing I will recommend. The second recommendation, again, would be, I will also suggest that we do receive complaints against Superior Court judges. My recommendation would be that the reform should include the fact that if a petition is filed against a Superior Court judge to the President and is given to the Chief Justice, the Chief Justice should give that petition to the three most senior justices of the Supreme Court. The Chief Justice should not make the prima facie determination. The three most senior justices of the Supreme Court should be permitted to assess that petition, and their decision, if the need for committee, will be set, otherwise is dismissed. These are the two things I may think. And also, we may want to have a police independent commission to assess complaints about police officers. The police should not have the opportunity to, that is law enforcement, should not have the opportunity to sit on complaints against police officers. This will be some of the recommendations I will make. Thank you.
Thank you so much. I don't have a follow-up. My second question would be on what areas will you suggest as a judicial reform to ensure efficiency and reduce delays?
Mr. Chair, thank you. I think it might not be much of a reform, but building capacity of judges should be something that we think about. We are asking questions about incompetence and so on and so forth. I think judges' capacity should be built. And that means that we should be able to provide financial support timeously to the judiciary. I work as a partner of the JTI. The director has many programs, but there's no money to train judges. So I think that must be done. Just imagine you being paid in June 2025, the last quarter payment of fuel for you in 2024. So I think that the financial support ought to be given. We're talking about helping to avoid delays. We need to take a look at our rules. Some of the civil rules must be looked at. Recently, there was a provision in regards to juries. Let me say this. The jury system is a good system. The whole idea is that your peers have listened to your case and they have ruled on it. Can we have a statute where every Ghanaian of 21 years' name can be on the list of jurors at district assemblies, so that private individuals, everybody can be a member of a jury, rather than public servants who are the only ones who are chosen? And when the pool is basically enlarged, you have many people who will be willing to serve as jurors. And it's one way of enriching it. And let us have criminal matters day-to-day trial dates, so that when we start a trial, you should not be dealing with a criminal matter with a jury from 2022 in 2025. Let's have a system where criminal matters we start and we can complete timeously. Thank you.
Thank you so much. I think I like the jury system because I've ever served on the jury in the U.S. and Jersey City. My last question has to do with this fear of tribunals. The NDC government wants to reactivate the tribunal, the government of the day. It's in the Constitution, but it looks as if it's not being used. It's here. It's 142. 142. Constitution is here. And I want to find out if it is legal Why do they have this fear? Thank you.
Mr. Chair, the honorable member asking me to assess why people have fear. Unfortunately, I will not be able to find out why people have fear. The reality is that it's part of the law. It has not been used for some time now. It is being set up to deal with, we cannot shy away from the fact that we have delays in our system. Is it being brought to help clear this delay? Is it being brought to be given specific jurisdiction to deal with certain matters? I think it depends on what is the policy rationale in wanting to bring this. If that policy rationale is anchored in law, I do not think that anybody would be opposed to it. Thank you very much.
Thank you, my lord. I think it's coming to address the backlog and the delays. Thank you so much, and I wish you well. Congratulations.
Honorable Patrick Yauboma, Senior, you have the floor.
Chairman, just to congratulate you, I don't have any question for my lord. I don't have any question for you. Congratulations. Thank you.
Thank you. Thank you very much.
Thank you. I'll proceed to give the floor to Honorable Haji Aladi Ayamba. You have the floor.
Thank you, Chairman. Congratulations, my lord. I have just two questions. One of them is about the retirement age of judges of the Court of Appeal and then the Supreme Court, which currently stands at 70. I have heard from certain quarters that we are thinking of 75. What is your opinion about it? And if you've heard it, that's if you are aware.
Thank you, Mr. Chair. I think I became aware through question of my other colleagues here. The reality is this. I think I do not have any statistics, but indication that people retire at 70 and within a short time, they join the other side. The work of a judge is a stressful one. You burn the midnight oil, you sit up and write judgments. So I think that 70 is good enough. And let me say, even in other jurisdictions where they have 75, when you are about hitting 70, you can choose to be a supernumerary, which means that you've cut down your work, you choose what to do, and they'll rather give it to those who are young. So as my brother who once said here, I think the 70 is good enough. Let's stick to it. So that when we retire, we can have time to spend with family. Thank you.
Chairman, my second question is about our districts with courts and the lack of judges. I think this is about my third time of asking this same question. What is your suggestion on how we will be able to get judges to, I should say, the 216 or is it 17 districts as at now, so that we don't continue to delay cases, denying justice to people?
Thank you, Mr. Chair. I think the occupation of a judge work must be attractive. There are many lawyers who may desire to be judges, but if you join the bench and after 6 months you've not been paid because your name has not gone on the system, within that 6 months of your service, how are you supposed to support yourself? So let's make the job attractive. As we speak, my beloved Bogoso has a court yet to be inaugurated, and I'm sure the people there are yearning to have a judge. But if people are not willing to join the bench because the package is not attractive, speak with those on the lower benches, their situation is not the best. So let's make the job attractive, and I think we'll be able to have the best of the brains to join the bench for the benefit of our nation. Thank you.
Thank you, Mr. Chairman. I wish you all the best.
Honorable Jerry Ahmed, you have the floor.
Thank you, Chair. My Lord, congratulations to you, and you're welcome. My Lord, I've just perused Article 1461, and it talks about a justice of the Supreme Court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior. I'm not going to talk about or incompetence. I want, in your view, to tell me what would constitute stated misbehavior. If you have about 5 of those or less, it's fine.
Thank you, Mr. Chair. I think this is not defined clearly, but I think what is a misconduct, all of us, when we see one, we should see it. There is a Canadian case called Mary DeBow. What was deemed to be a misconduct was a judge sitting who became so frustrated with people who are in her court, and she made statement that they are lazy, they don't want to work, all they have to do is to engage in criminality. That statement was deemed a misconduct, and she was removed from the bench. Okay? I've been a member of an investigative body where a judge in the Upper East was sitting and didn't have a copy of the minerals and mining law. A lawyer agreed that, my lord, when I get to Accra, I'll get you one. When the lawyer got the law, the mistake the lawyer made was, instead of taking it to the registrar, gave it to the client, and the client was going to give it to the judge. Somebody saw the person entering the judge's home, and a committee was set to investigate this as a misconduct. Of course, the committee eventually exonerated him, because we know that the litigant should not come to your home. So I think that many of the things that judges are required to do based on the ethics, if you go contrary to it, clearly may constitute a misconduct, depending on the facts to be determined.
Thank you very much, my lord. So my understanding is that stated misbehavior depends, or misconduct depends on the facts to be determined. But these facts, as we have not seen the definition of stated misbehavior, in your view, what should we do about it? Should we define what stated misbehavior is?
I think at this stage, at this moment, Article 146 has become a topical issue. Maybe it's high time we have a CI or regulation, so some of these things can be properly defined, and everybody will know the parameters of what these are. Thank you.
My lord, this also brings to mind, I know you are the kind of person who is very technologically inclined. I mean, I remember the last time I was before you was when you were in the High Court, and you had your own computers and things before you. So I labeled you as a gadget master. I want to find out, with the advancement of technology, the president is not in town, he's not in Ghana. The vice president is not in Ghana. The Right Honorable Speaker is not in Ghana. At what stage would technology be beneficial to all the 3 that are not in Ghana? What would be your recommendation? Who is the president? Or who can be termed as the president?
I think, if I understand your question, if the president, for example, is in Geneva attending a UN program, and the vice president is here, can we clearly say that out of the jurisdiction based on technology now, the person is absent? I am of the view that if matters can be regulated from there, depending on the situation, because the absence within the jurisdiction may not be the basis to say that the person is absent. I think we are in a situation where even judges, we should have a situation where a panel, one may be somewhere, if they can be linked up virtual to hear a matter, should be possible. So that's how I look at it. We can all take advantage of technology to answer some of these nuances. Thank you.
So would that be part of the recommendations you would pass on with reference to your issues on constitutional review?
Yes, I think some of these parameters must be clearly defined, and once they are distilled out plainly for everyone to understand that in such situations, the president or the vice president ought not to be deemed to have been absent and can still carry on his or her job, that will be very much welcome, so far as it has some statutory backing. Thank you.
Very excellent. My lord, I just want to find out, how can the Supreme Court ensure some balancing with reference to, or in respect of freedom of expression with the need to combat cybercrime and online misinformation?
I think in an earlier question, I quoted Lord Denning in British Steel Corporation. You know, I think free speech is not cheap. People should have the right to express themselves. But in expressing yourself, it should not be an avenue to abuse people and to defame people. We should recognize that online abuse is more serious than the old traditional way, because whatever you write here could be read in Australia or my made-up town of Ochebompito. They will read it there, and it may be online, it will never go. So I think once we want to allow people to have free speech, there must be responsibility attached to it. And so I believe in free speech, but free speech must be with some responsibility. Thank you.
Does that mean that people should be extremely careful as to what they say and when they say and where they say them?
I would say that social media has not done away with our old tort libel laws. They are still applicable. So that if you choose to go contrary to the law on social media, as I said, in Pakenham versus North Carolina, social media was deemed to be like you sitting at a public park and you uttering something. If that will be taken as serious, if you do it on social media, it should be taken as serious. Libel laws are still applicable. Let's be very careful about what we put on social media. If you go contrary, somebody ought to sue you. The court will hear that. Thank you.
Well, this will be my final question. Would you recommend that the Chief Justice's functions of being a judge and an administrator should be decoupled? Should we have just the Chief Justice doing the functions of a judge, and should we have an administrator doing the functions of just an administrator?
Thank you, Chair. Insofar as the Chief Justice is seen to be the head of the judiciary, I think that decoupling may not be necessary. I think it happens virtually everywhere. It ought to be a balance on the part of the particular Chief Justice as to how much work he or she wants to engage in the courtroom and how much work he or she wants to engage in administratively. So I won't call for a decoupling of that. Thank you.
I was looking for that. Thank you very much, and I wish you very well. No further question.
It's now the turn of Honorable Roxanne Nelson.
My Lord Ackaah-Boafo, you're welcome. JSC soon to be. I'm very proud of you. I lost a case before you.
Is that your question?
I appealed, but I know I won't succeed because your judgment was sound. I tried the matter on a very thin line, but you distilled the law, and your writing style as a judge, it's unique. My question will come. You are in the mood of Justice Francois and Taylor and Co. And I urge you to keep it up. You write extremely well. Now, the question has been posed to your other colleagues regarding the non-definition of misconduct being a basis upon which a judge can be removed from office. But I differ. So here is my scenario. You judges have a code of conduct for judges and magistrates. And Rule 2 of that code says that a judge must avoid impropriety and appearance of impropriety in all of the judge's activities. That's contained in page 3 of the Code of Conduct. Is it not the case that where this is breached, this will amount to a misconduct? You are a lettered man. You're a man of letters. A code of conduct, if it is breached, if any of the rules in the code is breached, it will amount to a misconduct. You agree with me?
Thank you very much, Chair, and I'm humbled by your initial comments. Let me say this. Yes, it might amount to misconduct, but should that misconduct, depending on the facts, be the basis for removal? In other jurisdictions, judges may receive a reprimand, some may receive you writing an apology, some may receive counseling. So I think that, yes, depending on the facts, the misconduct will be established. But would that amount to a misconduct that leads to a removal? It's another matter. Thank you.
My Lord, you took the wind out of my sail, because my second question would have been, that's why I said, if any portion of the code is breached. Now, to breach a code, it means that will have to be established based on the facts and the evidence. So when it is established that the code has been breached, then the second stage will be, what are the penal sanctions applicable to the breach of that particular code? So once we have a code of conduct for judges, every other matter regarding the removal of a judge will have to be based on that code of conduct. And so we'll leave this matter. Now, my issue is this. I'm waging an advocacy here, and it's in respect of career magistrates. Career magistrates don't receive equal pay for the work that they do with their professional career magistrates. Will you join me to ensure that they receive equal pay for equal work? And by way of providing further and better particulars, professional magistrates, they are entitled to official accommodation, official vehicle, official everything. The career magistrates doing equal work are not entitled to official accommodation, they are not entitled to official anything, save for the nominal salary. And I believe that that amounts to great injustice being done to them, especially when they don't have the opportunity to progress. I think 3 of your colleagues who have been here progressed from the magistracy all the way going to the Supreme Court.
Mr. Chair, well, I think I will join you insofar as they do the same job, but ultimately, you are here, you are the one who makes the laws. I'm not sure any career magistrate mount a court without a statutory backing. If you, who is waging this advocacy, is of that view, then I will respectfully ask that you ask your colleagues to join you so that you have a law that will support the position. But on the periphery, I agree that if people are doing the same work, then they should have some benefits, because in other countries, Uganda and other places, they still use some of these magistrates, and they have a better way of treating them. Thank you.
My Lord, your answer gives me opportunity to come back. We have enacted the law. That's the labor law, the Labor Act. Labor Act is very simple, that you must pay a worker for the work that he's done. You don't discriminate. So equal work, equal pay for equal work. Now, I've run into problems because I'm rather told that it's a policy of the Judicial Service. And I've raised the breach of the Labor Act many, many times at the committee level. So while you've given me an indication, I may have to push this further and actually insist at the committee level that that policy must align with the terms of the law. So I thank you for your opinion. And let me wish you well. We'll have the opportunity to come before you. I wish you all the best. Thank you.
Thank you very much.
I'll then proceed to give the floor to Honorable Patricia Appiah.
Deputy
Right,
Minority
thank you very
Leader.
much, Honorable Chair. Honorable Nominee, I've had a critical look at your CV, and it has actually exposed me to a number of things that I have ever overlooked. When you were giving us a brief about who you are, I noticed that I've always held the view that there's only one St. Augustine's school, and that's St. Augustine's Cape Coast, the college for which my brother and my leader attended. But it's good that you have exposed me that there's another one hiding here. Because when I was going through your CV, I was like, who in this world will leave St. Augustine's and go to Winneba Secondary School? That was my first impression about your CV. So I now get the difference between that. But my first question, since we're being watched and we have other people looking and following us, I wanted to find out why you did not complete your licensure course. Maybe it will inform people out there, where people who want to undertake such courses. Maybe if you can give us a little detail about why you abandoned it. Thank you. Thank you, Mr. Chair. Madam Member, I think I did because I found out that I'm more of an advocate than academic at the time. And I found out that the courtroom was rather my calling rather than the classroom. So when the opportunity came that I migrate to Canada, I think I chose to migrate to be a practitioner rather than academic. Thank you. Another observation I made on page 4 of your CV was about your national service history. You happen to have 2 different engagement, or I should say employment, within the national services. Your first one was at Wasa JSS, Wasa District for national service, and the second one was Aboso PDC office. What were you doing there? Thank you. PDC office. Yeah. Thank you, Madam Member. As you can see, there are 2 years. Unfortunately, I'm not so brilliant in maths. So my O-level maths was aggregate 7. And I couldn't, so I had to redo it. What it meant was I had to do 2 years post-A-level national service before going to university. So that is why you see 2 places there before my university. Sorry, what is PDC? Well, at the time, I was from the Wasa West District in Takwa. So I think these were organizations during the revolutionary days. They called them public defense committees. So national service persons like me and some from the university were placed there. They were taking complaints of people, and we became their clerks, writing notes for them. Thank you. Right. Thank you very much, Honorable Chair. I know that we as individuals, we have our own affiliations, we have our religious ties, and sometimes we have our own extracurricular activities. And as we speak now, I know that you may be holding membership in some political organizations, religious, and some other businesses. May I know what could compromise your impartiality when it comes to giving judgment in a particular situation where your association, as I have already indicated, matters? Thank you. Thank you very much. Let me put it on record that I am not affiliated to any political organization. I'm not affiliated to any business as of now, apart from me being a member of the Full Gospel Businessmen Fellowship International. But I think impartiality and conflict of interest come in handy if a judge takes the position that his or her views will be challenged in terms of what is placed before you. Let me put it on record that I actually had opportunity to write an opinion against my own brother's law firm. I proposed to the panel that I wanted to recuse because I know my brother. They said, well, but it's not his personal case. And I happened to write a judgment, and he lost. So I think it comes down to one's personal integrity as to whether or not you think you are conflicted. And if you strongly believe so, you must quickly and immediately recuse yourself. Thank you.
Thank you very much. I listened to your answer on the reintroduction of the public tribunals. And I was wondering, why are we not looking at ADR, which is alternative dispute resolutions, and we are only looking at the public tribunals? Would you please explain clearly why the difference between the two? Thank you.
Thank you very much, Mr. Chair. I think ADR is already part of our justice system. In many courts, you have ADR offices, and they deal with civil matters the more. If I understand it, the whole idea of public tribunals, their jurisdiction was more of criminal matters, so that the two are not the same. ADR, by the virtue of the fact that we have the ADR Act, and many Ghanaians are using it, which is one of the best ways to help decongest the courts. And in ADR, the parties must agree. If you are being prosecuted by the state, I'm not sure you can say that states, please, let's go to ADR, unless after you've been charged, you take the position that you want to engage in a plea bargaining. So I think that is where the difference is. Thank you.
Thank you very much. Honorable Chair, I have one other interest. Would you agree with me that public trust in the judiciary is declining, partly due to perceived politicization and corruption? How do you intend to contribute to restoring confidence in the judiciary, if approved?
Thank you, Mr. Chair. I think the judiciary, as I said initially, ought to be the integrity of the land, ought to be the arbiter of the land. So that if the judiciary is perceived to be corrupt, it is bad. But Madam Member, I want to say this. We seem to create the impression that the moment people get into the judiciary or some institution, they then become corrupt. I think there are serious philosophical questions for all of us as Ghanaians to ask. Because we must be corrupt before we join these institutions. So I think we should have that deep introspection as a people to understand, are we really corrupt? If we are, then we need to address it, rather than placing it in sectors and in institutions like the judiciary. I've heard many of my senior colleagues say there's the judiciary and the judicial service. That is a fact. So any perception of corruption is bad. But I think the time has come for Ghanaians to have that deep introspection, that people don't become corrupt because they've joined the judiciary or they've joined the police. We must all find out, are we men and women of integrity? Thank you.
And my last question. May I know from you, what is your legal and moral perspective on child marriage and witchcraft accusation as it stands now? Thank you.
Thank you very much. I think that the girl child should have the opportunity to be educated. The girl child should have the opportunity to develop her talent, so that placing any child into a marriage against their wishes at a younger age is certainly no-no. But why are we in a globalized society 2025 still talking about witchcraft? I think that these are nuances that as a people we may have to address. We accuse people of being witches, and you find out what is the standard for making such determinations. So yes, I do not believe that children should be put in marriages at tender age. Every child should have the opportunity to develop her talent. And if there is a need for us to regulate that through law, I am all for it. But I think in many of these things, it comes through education rather than just imposing law. Thank you very much.
My follow-up on that. You do agree with me that no matter how you look at it, it's something that is still with us. And education and legal education itself has not even helped. We're getting rid of such perceptions and ideas. Don't you still think that regulation will help to address this need? Thank you.
Thank you very much. I think my initial question was not doing away with regulations at all. I think that we can have laws because, as you indicated, there are some people, no matter how much you educate them, their mindset will not change. So that if we ought to use the law as a whip to draw them in line, that is perfect. Thank you very much.
Thank you, Mr. Chair.
Thank you very much. I'll give the floor to the Vice Chairman, Honorable Judge Kweku Tawiah.
Thank you very much, Mr. Chairman. Justice Kweku Tawiah Ackaah-Boafo. Mbona Juma. Na uti nkwaso.
Mr. Darcy.
Looking at your CV, in fact, I realize that you have quite a number of publications. You actually have publications, articles, and some presentations that you have done on quite a number of subjects, but legally related. The one that jumped at me is your opinion or papers you have done on African continental free trade, quite extensively. Now, so that's where I'm going to ask you a question to get your opinion on. You delivered a paper actually on dispute settlement on the African continental free trade. And my question to you is that, do you think, which is basically the subject matter, that African dispute settlement mechanism that the African continental free trade have developed at the moment is a hope for a much further integration of Africa? Thank you.
Thank you very much. In that paper, I actually criticized the legal mechanism. I criticize it because the system has followed the traditional one of making state parties standing, giving state parties standing when it comes to dispute settlement. And if I understand the African Continental Free Trade Area agreement, the thinking is to help individuals and SMEs to be the main players. And my thinking is that if they have not been given standing, then the challenge is if there is a dispute, they have to route it through their government in order to have this resolved. And I see that as a bit of a challenge. Having said that, we also know that the AfCFTA is anchored on the root of the World Trade Organization. There is a case called the Bananas case, where banana producers from Honduras and the rest sued, so that the nations can come together to help resolve that. For our purpose, though, I propose that the mechanism may not, as it is, give only state parties standing. That is why Ghana, where we have the headquarters, our judges must be trained on the concept of the African Continental Free Trade Area, because many of the disputes may start from us. And if we don't understand the agreement, I think we may use our Order 25 to impose an injunction, and the entire market may collapse. So as it is, it might not be the best, but it's the beginning. My hope and my desire is that the main players in the area may be given standing when it comes to this settlement. Thank you.
Mr. Chairman, with your permission, a follow-up question. I think I do agree with you. The African Continental Free Trade only came in at 2018, ratification in Ghana quite recently. There are a lot of dispute cases to come involving the 54 African countries if they all ratify. And I don't think the legal preparation, at least in Ghana, is adequate enough to deal with the dispute that will eventually come. Now, do you think that we will have to still take our cases to the international arbitration, or should there be an African molded arbitration for cases on the continent? Thank you.
Thank you, Mr. Chair. I think if we are talking about the African Continental Free Trade Area, the mechanism they have the dispute settlement panels, and then they have the appeals panels. And the thinking is that if there should be a dispute, this should be the means by which the dispute should be resolved. But as I indicated, the agreement gives only state parties standing, so that if Uncle Kweku's company is the one in dispute with a company from Kenya, then it's the state of Ghana that must be fighting for you. So that is where I take the position that the dispute settlement mechanism under the African Continental Free Trade Area ought to be looked at, should give the SMEs and individuals standing when it comes to this dispute settlement. But as we know, in many agreements, the parties themselves may have their dispute settlement mechanism, and so far as that is in their agreement, they are open to use that to resolve their dispute. But let Ghanaian judges be trained on the African Continental Free Trade Area, because we have the headquarters and they will come to us. And we ought to understand the market and how it will operate. Thank you.
I think I absolutely agree with you. Congratulations. And hope that you will start work on the bench soon. Thank you.
Thank you very much, Vice. We now proceed to give the floor to Togbi Osahi, Alexander Kwamina Aponyumaki.
Lord, may we go to your CV. Lord, you indicate in your CV that you speak, that's biodata point 2 of page 1. The last on that, languages written and spoken. 1, English. 2, Wasa. 3, Fante. 4, Tree. 5, Sehui. 6, Nzema. So you write Nzema and you speak in Zima, correct?
Mr. Chair, my writing will be a bit of a challenge after some time now, but the speaking, yes, I understand in speaking.
So you would agree with me that that requires some amendment. Would you,
yes,
with the leave of the chair, re-look at what you've stated there? You know, it's mixed up. So if leave is granted you, share with us which of them you write and which of them you speak.
Thank you, Mr. Chair. I mean, with your leave, I can amend it.
Please proceed with the leave of the chair.
I think I write and speak English. I write and speak Fanti. These are three. I think my writing has also become a bit deficient. So I will say English and Fanti I'm able to write. Wasa more or less is also like Tree or Fanti, depending on the symbols you are using. Yes.
My Lord, if we can go straight, sometimes I get worried when the impression is given that when it gets to me, there's a long delay for nominees. Please pay attention so that we can make progress. I'll plead with you. All right. So tell us which of them you speak, which of them you speak and write.
I speak and write English and Fanti. I speak English, Wasa, Shi, Seshi, and Nzima.
So, just for clarity, you can only write and speak Fanti and English, correct?
Yes.
Very well. Just for emphasis, you said you were your national service. You did it at two places. Go to page 4 of your CV. PDC Aboso office. So share with us. You know, the PDC was one of the organs of the revolution. It reminds Ghanaians of a certain past. Here we were, a young officer working in that office. A young officer who has now become a human rights advocate. Share with us what you experienced in that office.
Thank you, Mr. Chair. As I indicated to the earlier question, myself and another individual and another man who was a graduate from the university, we were sent there as national service persons. And what I used to do, within that, they have what they call an ABICOM, Arbitration Committee. And so people with some issues may come and make complaints there, and we were asked to write their statements.
So what was the system of adjudication?
Well, it included things like tenancy issues, and at the time, I must admit, to my surprise, when I became a lawyer, it even involved land matters. And the man who had, I think, a degree in land economy, he and one other senior persons were the adjudicators who will try and resolve these matters, and occasionally they will visit the lands and find out what land boundaries and so on and so forth. So the matters involve little things. Somebody is owing me, somebody has bought my tomatoes, they didn't pay. So people were bringing some of these matters there. Thank you.
Did you consider this as taking away the work of the judiciary. Of course, the revolution only took away the powers of the executive as constitutionally mandated and that of the legislature. But the judiciary was supposed to be left intact. Did you come to a certain conclusion that the PDCs were taking away the very work of the judiciary from what you've just shared with us?
Mr. Chair, at the time, I'm not sure I was that educated to understand that they were taking away the work of the judiciary, because apart from Takwa, which had a district court and a circuit court at the time, the whole area, there was no court. So from Abosu to Wasankran to Atrebuanda to Insusaiden, there were no courts. So these were ways people were resolving their matters. I rather thought they were helping people to resolve their matters rather than taking it from the judiciary. Thank you.
Lord, with respect, may we go to the Constitution, Article 128. The Lord may read Article 128.4.
Thank you, Mr. Chair. Article 128.1 or 4. A person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity and is of no less than 15 years standing as a lawyer.
My Lord, with respect, from what you have just read, how many essential qualities are required for such nomination?
High moral character, proven integrity, and at least 15 years standing as a lawyer.
Lord, with respect, on each of them, demonstrate that proof to me.
Thank you, Mr. Chair. On question of moral character, I think that I have demonstrated that through my life. I practiced law in Ontario for years before my elevation to the Supreme Court, to the High Court. A check was done from, there was no ever complaint at the Law Society against me. I've proven my integrity on the bench by doing my work. As I said, I have desired to always be unashamedly ethical. And come October, I'll be 29 years as a lawyer. So that is what I would say on this one. Thank you.
Chairman, your indulgence, I wish to raise a matter that strikes at the heart of our constitutional commitment to justice and fairness, the presumption of innocence. My Lord Nominee, we have observed an increasing pattern in which state prosecutors, including the Attorney General, convene press conferences or make public statements that cast serious aspersions on the guilt of accused persons, often long before a court of competent jurisdiction has had the opportunity to hear and determine the matter. This trend appears to risk eroding constitutional guarantees under Article 19(2)(c) that every person is presumed innocent until proven guilty. Indeed, the European Union has taken significant steps in this area, particularly through Directive EU 2016/343, which restricts the public dissemination of information regarding criminal proceedings to protect the fairness of trials and the dignity of the accused. Ghana by contrast, appears to be drifting towards a culture of trial by press and public opinion. And this was long observed by my Lord Apao in the Tagore case. My Lord Nominee, what I'm going to ask you, seek to explore your views on how to reconcile prosecutorial communication with the Constitution's promise of due process, judicial fairness, and respect for the rule of law. I will basically, like I've stated supra, rely on the constitutional provision of Article 19(2)(c), and we'll look at principles of fair trial due process, ethical prosecutorial conduct, and comparative standards from the European Union and other democratic systems. Now, how do you interpret the constitutional guarantee of the presumption of innocence under Article 19(2)(c) in the context of public commentary by prosecutorial authorities on cases yet to be sent to court or before the courts?
Thank you, Mr. Chair. On matters before the court, I think that as lawyers, each one of us ought to be aware of Rule 38 of the Legal Profession Act, which speaks to the fact that matters which are before the court, if you are counsel, you don't comment on them. So that will be my response, that any lawyer who leaves the courtroom and meets the press outside and begin to talk about what is happening in the courtroom clearly is breaching that rule. On the issue of providing information, I think that this is where there's a thin line. The thin line is that this society has grown a bit sophisticated and want to receive information. I think I've asked questions this morning about people on social media doing disinformation and misinformation. So that if the Attorney General takes the position that these are matters that I ought to place before the public to be aware of, it may be within the context of providing information. But if the Attorney General goes ahead to make comments alluding that the person is already guilty, in my view, that will be a breach of the Constitution. But providing information to the public who want to know that this is what we are investigating. I think receiving information from the right source is always better than getting it from the social media, which sometimes clearly are manipulated. Thank you.
Chairman, just bear with me, Chairman, bear with me. You see, I would prefer if leader wants to ask his own set of questions, under normal circumstances, I'm the last to ask, then you come in. If he wants to be the last after me, I don't mind. But this issue of follow-up, he should reserve all of his points. When I'm done, he can come in. I will plead with you, Chairman.
Thank you very much. We are Parliament governed by rules. So when a question is asked, the rules allow a follow-up question. So following the same practice within the rules, I will proceed to give the floor to the majority leader.
You quote the particular rule for our record. Which rule? You quote the rule.
A follow-up.
Chairman, please quote the particular rule.
So I will look for it.
Yes, you look for it. Let's patiently look for the rule, rely on to make a determination, and let it go in the records. Rule, quote the rule that allows somebody else to interject with a so-called follow-up when the person is entitled to his own, set of questions. So quote it.
The public, let's look at Standing Order 89. It's on supplementary question. And if I may read the relevant portion, 89.2 or 89.3. Any other member may be allowed to ask not more than 2 supplementary questions, except that the majority and the minority or co-leaders may ask not more than 5 supplementary questions on the substantive issue. It is on this order that I am standing to give the opportunity to the majority leader to ask a supplementary question.
Chairman,
so
with
order
respect.
89
Chairman, with respect. You may continue to exercise your powers, but let me help you. The rule you've just quoted governs plenary proceedings. If you want to apply it mutatis mutandis, you are supposed to still be guided. Because I am asking the question, that rule says, after the person asking the substantive question is done, I must be done with all my follow-ups. Before, then you would ask me, are you done? Before going on, I laid bare each of the steps I want to take. So you should ask me first, am I done with that substantive question? If indeed I say yes, and you want to apply the plenary rule mutatis mutandis here, you may now give him the chance, but don't say you are guided by the rules, and even when I am not done with my supplementary questions or follow-ups, you want to give him the chance. Let's stop this. The leader is entitled to come in anytime when we are all done. He can ask his own questions, so stop this. It won't help.
Honourable members, it's not everything that I place on record. You realize that before giving the opportunity to the majority leader, I asked the questioner that majority leader will want to ask a supplementary question, not into the microphone. So if you are not done with a supplementary question, you can also tell me that you are not done with a supplementary question on that particular question. That doesn't mean I do not have a floor or do not have the ground within the rules to ask the leader to ask a supplementary question. So if you feel that you have a supplementary question on the question that you have asked, you can ask that particular question, and thereafter I will give the opportunity to the majority leader to also ask a follow-up question. But rather, you said, which rule am I relying on? I have shown you the rules. So I'm not operating outside the rules.
There are rules that govern committee work. Chairman, anyway, I'm not done, so let me finish my supplementary. Now, let's deal with the issue of ethical guidelines. You have just spoken about the boundaries, that it could be in the public interest for the minister to put out some information. Now, do you think that there is a need to provide some ethical guidelines to govern this prosecutorial communication?
Thank you, Mr. Chair. And if I may seek clarity, ethical guidelines as to guidelines governing how ministers do their work, or with this particular situation?
Very well. So, in my first answer to you, a first question to you, you answered in a twofold. First, you said that if the Attorney General is saying anything that would prejudice the outcome of the case, then that would amount to a breach. Then you again said that it could as well be that there's a need to provide information to the public regarding the case in this era of social media and all. So on the basis of what you've told us, I am mounting the follow-up to ask whether on such a thin line you hold a view that there's a need for some legal or ethical boundaries that should govern public statements by the Attorney General or prosecutors about the accused persons before trial commences.
Thank you, Mr. Chair. I think that the Attorney General remains a lawyer. If there is any member of the Attorney General's office who is a lawyer, I would say that they still must advert their mind to LI 2423 as lawyers, and their roles as prosecutors are well set out in the LI. If the person is not a lawyer and will not come under that ambit, then maybe what you are asking may be appropriate. But I think your question clearly, hardly do we see police prosecutors, for example, doing that. So that if it is someone who already comes under LI 2423, then my thinking is that there's already some rules there governing how such work ought to be done. And in regards to public statements, that is covered under Rule 38. Thank you very much.
Now, to what extent do such public declarations of guilt by state prosecutors, even before trial, in your view, can undermine public confidence in judicial independence and the impartiality of criminal proceedings? My Lord, I would give you a bit of a background just to help the situation. My Lord, sometimes, the court is often accused of not ensuring justice, not being fair, all because a certain impression has been given them that somebody is already guilty. Why did the court even grant bail? Why is the court saying that he's acquitted and discharged? Why is the court using rules of procedure to free somebody? So, with this as a background information, would you say that to some extent, some of these public declarations, which in the ordinary man's language, understanding, amount to a guilt, will undermine the public confidence in the judiciary, because it's already been said out there, and you are now sitting in as a court of justice to determine the matter?
Mr. Chair, when it comes to judicial independence, clearly, as we understand it, there's decisional independence and institutional independence. The decisional independence is the judge's ability to hear evidence, the facts, and applying the law. So that I think I would rather be shocked that any judge who understands his role ought to be influenced by a statement made by a prosecutor or the attorney general even before the matter comes in. I would do my work, or judges do their work, based on the evidence they receive in the courtroom. Yes, for an uneducated mind, it might create the impression that the judge has done something untoward. But we only speak through our judgment. As a judge, when I write a judgment, I must have my spirit in it, so that when I have demonstrated that and you disagree, my position is read the judgment. And your opinion, you may want to disagree with me, but I have spoken. So yes, if providing that information will make people think that the person is already guilty, but the trial did not meet that standard, I think it rather undermines the integrity of the person who put that information out there than the judge. Thank you.
My Lord, I know definitely Apau J, as he then was, and his brother Pesera, the position they took in the very matter that our respected AG did in the Tagore case. It provides a new pathway, which you've emphasized this morning. But essentially, reading that judgment, I got the impression that you, the judges, are often concerned, or perhaps you are put under some pressure when the public perception is already out. Because if you see the way my lords emphasize the point that the fact that a case gains public notoriety does not whittle down the essential ingredient required to prove the guilt. It tells you one thing. It's on this basis that I want to ask you whether unmeasured approach in such public pronouncement by the prosecutor, in your view, undermines the very justice of the matter. In all fairness, you are on oath.
In all fairness, yes, let me say that, especially as a teacher of advocacy and legal ethics, I think I will be concerned when lawyers leave courtroom and make comments on matters pending, and sometimes the fact will not represent what took place there. I'll be concerned about that. But prior to filing the matter, if it is something providing information, I would think that might be appropriate, but there is a certain line. Do not make comments basically throwing somebody under the bus before even a suit is filed. Thank you.
Lord, then human rights, remedies.
Before you go to human rights remedies, I will proceed to give the floor to the majority leader to ask a question.
No, wait, Chairman. On the presumption that you've not, please. Chairman, you know, in my opener, I can share with you, this is the main question, under 19.2c. The remedies comes under, they are all follow-ups. So I only give the subtitle to help the nominee. So when I under the same thing, please, they are all my follow-ups. I have main question, I've drafted them carefully. So let me get done. He would have the opportunity, please. It's my follow-up. I'm the questioner. The rule allows me to ask 5 supplementary. So let me finish. They are not. They are 2. Chairman, they are here. I've listed. I'm going by my own work.
So to go by the rules that I have quoted, you are entitled to 5 supplementary questions. And the questions that you have asked following the substantive questions are more than 5. A question was asked whether or not he is a member entitled to ask a question. We should make reference to Standing Order 2177, which entitles him to participate in the decision. So you have the floor. You can ask a supplementary question.
Thank you very much, Chairman. I don't know when my minority leader started fearing me asking questions. That's the only sense I get, that, you know, you're so scared of me asking a question. My Lord, congratulations on your nomination. Will a prosecutor institute prosecutions if he doesn't presume you're guilty?
Thank you, Mr. Chair. Certainly, a prosecutor will believe in his or her case before they file it. And it doesn't always work the way it is. So, yes, a prosecutor is entitled to have an opinion of his or her case. As to whether or not it will meet the threshold is another matter. Thank you.
So your answer is yes, a prosecutor will presume you're guilty before he files his case.
That is correct.
So the presumption of innocence, is that an obligation of the court or an obligation of the prosecutor?
I think the presumption of innocence is more to do with the court than the prosecutor, because ultimately, when you are starting with the prosecution, I, sitting in that chair, must take the position that you are presumed innocent until I hear the evidence. If the prosecutor's mind is you are guilty, that is his prerogative, but that should not influence my decision. Thank you.
And for clarity, did I hear you say that before a prosecutor institutes the action, at the time of investigations and conclusion of investigations and the gathering of facts based on which the prosecutor believes that there's a basis for prosecution, if that prosecutor goes public with the details of the facts gathered that found his decision to institute prosecution and then announces his decision to institute prosecution, to the extent that he hasn't come to your court yet, you think that that level of sharing of information is okay?
That is my view, that provided that information, you've conducted, the prosecutor has conducted his or her investigation. He says that is what I have. I'm going to court. And he makes that, provide that information. It is fair game for the prosecutor. As to how, whether or not he will succeed in court is another matter. So yes, if the prosecutor provide that information, I think my only caveat is the prosecutor creating the impression in the mind of the court, in the mind of the public, that this is a done deal. That clearly will have a problem. I will have a problem with that, because that is when the minority leader's question then kicks in. Because in the mind of the public, the person is already guilty. So that when the court returns a decision, that is where the bashing of the court may come in. So I think it is a very nuanced way, or there ought to be a nuanced way of doing it. Provide information to the court, but as much as is possible, I think prejudicial comments ought not to be made. Thank you.
So, Honorable Majority Leader, be reminded that you have to ask 5 supplementary questions. Yes, so you have 2 more.
In North America, where you have practiced, when prosecutions are ongoing, do the media and lawyers comment on the proceedings, or that in some states, even the proceedings are covered live on television? Does that happen or not?
I call it the Johnny Cochran syndrome. It's more in the United States than in Canada. Matters in Canada, you don't comment on it. We stick to the rules, and you only have lawyers speaking to it after judge decisions are made. The Johnny Cochran syndrome is more to do with the Americans than the Canadians. Thank you.
My last question. The system of appeals that we have, from the High Court to the Court of Appeal, and ultimately, potentially, to the Supreme Court, and even a review, the system of appeals, does that provide the accused person remedy against any potential pressure that may inform a judge giving an erroneous ruling or not?
Certainly, yes. I mean, if somebody is not satisfied with a decision by the High Court, you can go to the Court of Appeal, and from the Constitution, they actually have a right of appeal. So yes. And in recent times, we've seen the Court of Appeal reversing some High Court decisions. So yes, it's a remedy. But the bottom line is, if there is a way to avoid this, can we find a better way of doing it? That would be my suggestion. Thank you.
Yeah, the floor is back to the ranking member. You have the floor.
Now, may I know from you, Honorable Nominee, whether, in your view, there are available remedies for accused persons who are publicly labeled guilty by prosecutorial authorities before a fair trial takes place. In other words, suspects who, before even sent to court, are publicly labeled guilty. If there are some remedies for them, in your view, my lord.
I find it difficult to look out for remedies, because, for example, in recent times, we've heard of lawsuits where somebody will go to court that injunct a public institution or somebody from investigating me. I do not think such lawsuits are appropriate. Ultimately, when you are being investigated and the prosecution says, I'm taking you to court, I would rather think that the individual may want to gather his or her information, and if at the end of the prosecution the person walks away free, then that may be the appropriate time to mount an action. Thank you.
Now, flowing from that, do you think that the judiciary must, and here proactively, intervene to restrain state actors whose conduct or statements are seen to be undermining the presumption of innocence rule?
I know as a fact, myself and other colleagues involved in matters would warn lawyers, counsel involved in the matter, not to make prejudicial comments when the matter is ongoing. But if the scenario as painted during the investigation stage, the prosecutor is providing information in the public, I do not see how the kind of jurisdiction that the judiciary may have to issue some injunctive orders or some orders against such a person. If they haven't come to us, we do not have jurisdiction to deal with such matters.
Given the opportunity, or when the opportunity avails itself, are you likely to come out with some judge-made laws to guide this process? In the light of your position in a recent matter, I read your judgment. You made a profound statement. Very well. You answer it. I'll go. That's my next thing. Do you think that there's a need for you to come out with some judge-made guidelines for this whole matter, given the opportunity?
Thank you, Mr. Chair. I think decisions of judges or judges make decisions based on facts, analyzing the facts, and applying the law. So that if the fact certainly is to that effect, that a judgment could be written to make such or provide such guidelines, I think that would be fine to do. So the simple answer to your question is yes, if the facts will support that. But I'm not sure I can sit here and say that based on the narration you've given me, I am going out there to write a judgment to gag an investigator. Thank you.
Now, some comparative analysis here. You know, the recent EU position, this recital 18 of the EU directive that I relied on, that limits the disclosure in the public interest or to assist investigations. Do you think that as a country, a growing democracy, we are almost 30 years plus, this principle should be seriously observed against this rising trend of political and prosecutorial commentary on matters of criminal jurisprudence?
Mr. Chair, I think as a democracy, we are building and we are learning. Mr. Member will recognize that until just from 2018, even full disclosure to an accused never existed. Now we have it. So I think that what you are asking for, I think that we may get there depending on how us as society, you as lawmakers see that. I think it's a conversation that can be had. But we need to understand that some of these situations come about as we learn and we want to educate ourselves. Thank you.
Lord, your senior brother, Eni Yeboah, JSC, as he then was, in the matter of Jesse, Emisa Texan, and two others versus the Attorney General, in suit number J1/10/2015, held in his dissenting opinion as follows, quote, "Before I rest I wish to make it clear that in our constitutional dispensation, care must be taken not to create a statutory institution without checks by the court on how they deal with the citizenry. Failure to hold them in check will be a throwback to the era of unlimited executive powers, which will certainly undermine our democratic dispensation, end quote. What are your own views on this matter as you rise to the highest court?
I think I see this as anchoring in the doctrine of separation of powers and the court having the duty to interpret law and be more or less as a watchdog or a guard against excesses. Of course, the court ought to recognize its duties and its functions. So that statement is profound based on the facts of the case as dealt with by Edin Yabua JSC. Many times, some of these cases come up, and I think if the occasion arises to re-echo such words, or as part of our education, that will be done. Thank you.
What about looking at it in the context of human rights? Looking at this statement in the context of human rights, have you any views on?
Well, I think with the greatest respect, we sometimes bandy things around as human rights, such that anybody at all sometimes will raise certain issues to say that it is my right. But we must always look at Article 41, I think it's in the K or J, which talks about the rights and the responsibilities. If the Attorney General, the prosecutor, has a role to play, and he says, I've investigated the matter and I'm providing information to the public, I think, as I've already said, that may be within the mandate. But anything else that may go on to prejudice the trial, certainly if the occasion arises, can be dealt with. Thank you.
But you've already indicated there's a thin line, correct? Yes. Very well. My Lord, let's deal with some food you have already served, the judiciary. You've cooked something. In your concurring opinion in the matter of Isaka Abubakar, alias Raga Jiwa versus the Republic, decided on 27 March 2025, as well as broader constitutional and legal frameworks governing arrest, investigations, due process, and personal liberties in Ghana, there are some few things that I would want to bring to your attention for your views on. I must say that these would further be anchored on Articles 14, 23, our Criminal and Other Offences Act, and of course, ethical standards for law enforcement. Now, at page 20, paragraph 25 to 26, these were the very veritable words you used, and I quote you. My lords, another aspect of this appeal on which I wish to express my opinion concerns the reason for the appellant arrest in the first place. In my view, this case, like a few others I have had the opportunity to review, presents and reveals a troubling trend in the manner in which investigations are conducted by the police and prosecutions are carried out in our courts. In this case, I question why the appellant was arrested, as the record of appeal reveals that, apart from the statement of persons arrested alongside the appellant, who indicated that he was part of the robbery, no independent evidence linking the appellant to the robbery was obtained by the police. You further went on at paragraph 26, and these were your words. Quote, my lords, in my respectful opinion, the time has come to be blunt with investigators. Arresting an individual solely based on another person's statement without a thorough independent investigation poses significant risks. Apart from the obvious ethical lapses inherent in a laissez-faire attitude towards investigating accusations, the accuser may have personal motives such as revenge, bias, misidentification, or even deliberate deception or deflection of attention from actual perpetrators, leading to wrongful arrests. Moreover, such practices encourage arbitrary policing, fostering abuse of power, and the erosion of public trust in law enforcement. They also create opportunities for individuals to manipulate the system for personal gain, using arrests to settle scores, eliminate rivals, or shield actual perpetrators. It is imperative that investigators recognize the necessity of conducting proper investigations supported by corroborating evidence such as forensic proof, surveillance footage, and credible eyewitness testimony to mitigate these risks and uphold justice, unquote. My Lord, from what you stated in your concurring opinion, you criticize the police for making arrests without independent investigation. What, in your view, are the constitutional obligations of investigators before depriving a person of their liberty under Article 14, respectfully?
Thank you, Mr. Chair. I think my view is rightly captured in the dictum you read out. I am of the view that, and as I indicated in that case, the record reveals that apart from those who were arrested with him saying that he was part of us, there wasn't any investigation that was conducted to link the individual. And these statements were actually even not repeated in court, apart from caution statements. So that is where the statement comes from. My view is that there is a need to have proper investigations and not a co-arrestee say so be the basis for prosecution. Thank you.
Lord, flowing from this, you, like, as you've already indicated, you've won against arresting individuals solely based on statements from co-accused persons. How then should the judiciary guard against arbitrary arrests that are used to settle personal scores or suppress rivals? How should the judiciary boldly confront this to guide our democracy and the rule of law?
Thank you, Mr. Chair. I think it depends on what stage we are at. If an investigator comes to court and he said, I've done this investigation, I arrest somebody and put a person before the court, I think at that stage it will be difficult for a court of law to say that at that preliminary stage there's no basis, let him go. The only way the judiciary can confront this is when presented with the compendium of evidence, assess it, and say that there wasn't no basis for this arrest and no basis for the prosecution. So, and I think we've done so far. We've done well so far when it comes to such things. If ultimately there's no evidence, there's no evidence. And the court makes a decision. Thank you.
Lord, now you are going to the policy court, where you will want to propose reforms. So let me ask you, it's a court of liberty. Nobody would be up to be checkmating unduly, except perhaps, of course, the matter comes up for review, or long after you've left, a new panel comes up with a new view, which is the case in our courts. But for the time being, you've described this laissez-faire attitude in policing as a threat to public trust, and I agree with you. What, therefore, in your view, should be the legal or institutional reforms necessary to ensure investigations are thorough, ethical, impartial, and conclude in good time. And conclude in good time.
Thank you very much, Mr. Chair. I think I would take a cue from my last answer. If until matters are filed in court, based on our rules, based on the laws in the country, I think the court will have very limited role to play until matters are filed. So that these guidelines ought to come from the Ministry of Attorney General and the prosecutorial services to guide this. But we know we also have matters of delay in our rules. In other jurisdictions, they apply so well, where no matter the charge, it could be stayed if the matter has been unduly delayed. So these are things that we can have conversation about. Should somebody stand trial for 5 years without calling any evidence? These are conversations that we can have. But I'm not sure at the investigative stage the court will have much to do until matters are filed. Thank you.
My Lord, the police prosecutor comes to your court, says that a big man, a businessman, has reported of stealing. The stealing was a check that, of course, he signed a blank check. And the house